Well, Doug, thank you for being here. It's really great to see you.
Great to see you again, Chris.
Yeah, fantastic. Obergefell at 10 years. In some ways, it's hard to believe that it's been 10 years. In other ways, it's hard to believe that it's only been 10 years since, marriage equality is so familiar and commonplace these days.
Isn't it? It's remarkable to me in some ways how far we've come on that particular issue, and yet we've also had frequent reminders of how far we have to go. So
Yeah, so I guess just to start things off, why don't I just talk about NCLR's history with the freedom to marry? We've been involved with the marriage equality movement since there's been a marriage equality movement, if not before. We represented, along with our partners at the ACLU and Lambda Legal, the plaintiffs in the California State Court marriage case that started in 2004, led to a great decision that our Vice President of Legal, Shannon Mentor, argued in the California Supreme Court. We later brought state court cases in New Mexico and Florida. At the time, the thought was that we wanted to build momentum for marriage and to start in the states, in states where it seemed possible to get good decisions from state Supreme Courts, and then at that point to pivot and potentially bring a federal case. And at the same time, there was an effort by GLAD and the ACLU and others to challenge the Federal Defense of Marriage Act in federal court, again to lay the groundwork for a federal freedom to marry case. And that led to, and DOMA, by the way, for those who maybe are a little younger, was a federal law that was passed in the 1990s, that denied all recognition for federal purposes to marriages, even in states where marriage was legal. So if someone married in New York, which passed marriage equality, they would not be recognized as married for federal purposes, Social Security and so forth. That law finally was struck down by the Supreme Court in 2013 in a case called Windsor. At that point, it became clear to, I think, everyone that the movement for freedom to marry was going to really kick into high gear, and we were going to see federal cases all over the country. So we at NCLR got involved, became co-counsel in a case that had previously been filed, a federal case in Utah. That was the first case that we got involved in. And then around the same time, we filed our initial case in Tennessee on behalf of three couples who had married in other states and then moved to Tennessee, only to find that their relationships were not going to be respected by that state. That was followed later by cases that we filed in Idaho and Wyoming and Alabama and North Dakota and South Dakota, either filed or became co-counsel in. And we got, in the cases that went to decision, we got excellent results from the federal district courts. Those appeals then were taken, and we got a positive appeal from the 10th Circuit Federal Court of Appeals in our Utah case. There was also a positive decision from the 4th Circuit in Virginia. And so we had this situation where large parts of the country had the freedom to marry as the result of federal court decisions. The Supreme Court initially declined to get involved in that, let those decisions stand. But then, after getting a very good decision from our district judge in Tennessee, that case, along with cases from Michigan, Ohio, and Kentucky, went to the 6th Circuit Court of Appeals, where we got the first negative decision from a federal appeals court. So we had a situation where part of the country had the freedom to marry as a result of federal decisions, and part of the country didn't have it as a result of federal decisions. It was clear at that point that, the Supreme Court was going to have to step in to resolve that. And the timing of the Tennessee decision from the 6th Circuit was such that we knew that if we did not get to the Supreme Court with a petition asking them to review it within like a week, we were not going to have any chance of getting a decision from them for like another year. And that's where you came in.
Yeah. Well, first there was an email from you.
Yep.
When I've recounted that, I have a very, very vivid recollection of it. And I was driving home. It was Friday, and I was in DuPont Circle, and I was stopped at a red light, and that's very important because I looked to check my BlackBerry, and there was an email from you saying you were representing the plaintiffs in the Tennessee case, and you wanted to go to the Supreme Court, but you needed to go in a week, and would we be interested? And as I always say, that is the kind of email for which one pulls over and calls to respond right away, which is
Yeah. Yeah.
what I did. And but to me it was important. Like, I remember when you won the first case in California, and you and I obviously we go way back. I've known each other in college, and again together in law school, but we had kind of been out of touch for a few years. And I remember seeing your name on the California decision, and I reached out to congratulate you and thank you for what you were doing. And it just felt so wonderful to me a few years later that you were reaching back out and thought that I could contribute in some way to that effort.
Yeah, and it wasn't just a random email either. Doug, for folks who don't know, worked for many years in the Office of the Solicitor General, which is the office within the Department of Justice that argues cases before the Supreme Court. You had personally argued quite a few cases in the court at that point already. And we knew that we really wanted to get an experienced Supreme Court advocate to help us with the petition and to make sure that we were presenting the court with the best possible case to take on this issue and to hopefully resolve it in our favor. So Doug, I wonder if we could pivot to maybe the process leading up to the argument and how that all took place. All four cases, the Kentucky, Michigan, Ohio, and Tennessee case, were put together. So we had a lot of attorneys from a lot of different organizations involved. And the decision was made that you would be one of the people arguing the case, and also Mary Bonato from Glad Law in Boston, who was counsel in the Michigan case, and with whom we've had a very close working relationship for many years and still do, would be the two attorneys arguing on our side. Can you maybe talk about kind of the process that you followed and that we all followed to get the two of you ready for argument?
Right. Well, you started talking, Chris, about the NCLR strategy about trying to litigate this at the state level and looking for wins there upon which to build. And obviously there was a lot there. I mean, you're going back to the Massachusetts decision was the first and sort of started the progress being made. But another way in which you were thinking about that kind of incrementalism, what I remember from our conversations was that the Tennessee case was made up of only couples who had already married in other states and then had moved to Tennessee for purposes of their jobs. One or the other spouse, or in one case both, took jobs in Tennessee, and then upon arriving, they were no longer treated by the state as though they were married, right? And that was a choice that was also reflected an option for the court to engage in incrementalism, if that's what they had wanted to do. The thought being the court had issued this decision in the defense of marriage case that obviously held that the federal government could not refuse to recognize valid marriages under state law simply because the married spouses were of the same gender. and there's a lot of great language in Windsor about, the dignity of those individuals and couples and their marriages. But there's also stuff in that decision that makes it read like a federalism decision. States
Yeah.
have always regulated marriage. We look with some skepticism on a federal law that departs from the normal way of doing things, where the federal government just picks up whatever marriage means in the various states, right? And so by choosing to have three plaintiff couples who were already married and then moved to Tennessee, there was kind of like this additional incrementalism that the court could have said, well, look, it would be very unusual and contrary to historical practice for a state to recognize the marriage of a couple who were validly married where they were married. And so, initially it sort of offered that opportunity, but as you indicate, the court took 4 cases all at once. And 2 of those cases were cases in which the plaintiffs were not yet married, and they were asking for the right to a marriage license in their states. And then in 2 of the cases, the plaintiff couples were already married, and so we're presenting this recognition question. And I'm sure you recall that what was initially thought of as an opportunity for the court to move more slowly, if that's what it wanted to do, now that those cases were up together at the same time, immediately everybody was concerned that our case, ours and Ohio's, would be the Trojan horse, would provide an off-ramp for the court to give less than full vindication of the rights of gay couples to marry. And so, a really important thing as we started to prepare was, how did we make sure that our arguments were reinforcing the arguments in the licensure cases rather than undermining them, right? And so a lot of our prep was prepping, across all 4 cases and making sure that we're aligned, making sure that whenever, there was some issue where somebody might try to, drive a wedge between the sets of cases, we would have a response to that to push back. And, I remember, everybody takes seriously preparation for oral argument in any court. In the Supreme Court, it's very traditional that you not just have one practice argument, but you would have 2 or 3. I think in this case we had 5, different levels of practice arguments, and many of them were full-fledged, 9 mock justices, from the Supreme Court bar and from academia, people who were loaded for bear and gave me and Mary a thorough workout. And it seemed to me, I'll tell you, at the time, I felt like at the first of those I was fresh and I really felt good coming out of that one. And then at about the 4th, I was just feeling like, oh my gosh, I'm getting raked over the coals. And one of the things that happened, toward the end of that, was feeling like we needed to get back to some of those basic premises, the real, the themes that had struck us at the very beginning and that had animated the first of those moot courts. And we did that. We kind of went back to that. And I think that was really important. And one other thing that was really important to me personally, but then in the end, I think to the argument, was, and I suspect you'll remember this, that the day before the argument, there was actually a get together of all of the plaintiff couples, and I'm sure it was an enjoyable event. I did not go because I was fully focused on getting ready for argument. But I went and met with our Tennessee plaintiff couples. And it was the first time that I had met them. I'm here in DC, they're in Tennessee. And we hadn't had a chance to meet before then, but really having a chance to meet them, to see them, for them to be, real persons, to hear a little bit about their stories, to hear a little bit about what was going on in their lives, actually was really important to me in sort of like helping me to weave some of those real life stories into the argument. And we can maybe talk later about the actual argument, how that came out. But, I felt that in the end, we succeeded in what we had set out to do, which was to make the recognition question not, some kind of Trojan horse, not the off ramp, but actually a way to reinforce for the justices the justice of our case, and the need to validate and vindicate the right to marriage in its entirety.
Yeah, I recall that very clearly. We all wanted to make sure that we were, shooting for the home run, and that we not have anything in the argument, the two arguments that made less than that an attractive option for the court. And I think our married plaintiffs from the Tennessee case were excellent in reinforcing the basic principles that led the court ultimately, I think, to recognize a right to marry nationally. These are folks who married in other states, then moved to Tennessee because they wanted to pursue their dream jobs, or in Ipa's case, because he was in the military and that's where he was supposed to work, and or in Matt and Jono's case, because Matt got transferred with his job. And those compelling stories, some of them ended up in this court's opinion in the end. I think really underscored the point that everyone deserves to have the protection of marriage. Especially those raising kids, like two of our couples were.
You mentioned two of the points that I remember emphasizing. It's often said that the Supreme Court, you're not supposed to personalize it. It's not about the individuals, because it's about the big legal principles. The court's deciding this for the whole country, and not really in some respects an individual case. But during the rebuttal period, so after I had opened and then the state counsel had argued, and I got to get back up, I think by that time they were exhausted, the justices, and they'd run out of questions. So I kind of had about 5 minutes to just sort of respond and use some of those examples to really underscore how the government's arguments and its interests just all fell apart, right? And was able to use those examples, right? Like Matt and Jono, you say they had married, and one of the spouses had given up his job so as to be a full-time parent, right? And could do that because the laws around a family that support the family, provided, insurance and health care and, benefits if God forbid, Matt was to pass, and allowed them to invest in their children, just the very things that the state was saying it wanted. But then, the state law, if they would have won, would have destroyed that, right? Everything that, they had done in reliance on the law to invest in their family and their children had been, ripped from them. And I recall learning at that meeting the day before argument, when I first had a chance to meet in person with the plaintiff couples, hearing from Valeria and Sophie that their daughter had just recently been in the hospital, and that it was only because of the initial injunction that the trial court had entered that both mothers' names were on the birth certificate, and both were therefore able to be at her bedside in the hospital, rather than one of them being treated as a legal stranger. And I thought that those points were so important for the justices to hear, not just about their individual cases, but about the real life impact of the law in this area. And I do think that, if anything, it made the case for, marriage rights generally to be all the more compelling.
Absolutely. Absolutely. Well, Doug, maybe we could shift to the actual day of the argument and what that was like. It's easy for me because I got to be a spectator. So that day for me is mostly filled with memories of spending time with our couples, being on the courthouse steps with them, and seeing all the crowds, the huge crowds that were there waving banners and being there to support the couples. We took a picture of all the couples in all the cases on the courthouse steps.
Yeah.
And then when we got into the courtroom, it's not often that you get the sense that you're living history in the moment that you're doing it. But that was certainly a time when I had that feeling, both that day and the day of the decision. It became very, very real when we got into that courtroom. And the most surprising thing for me is sort of how small that room is and how close you actually are to the justices on the bench. I was probably, I don't know, 5, 10 feet behind you, and the justices were just a few feet in front of you.
Yeah.
So why don't you talk about the argument itself?
So I'll start by maybe sharing. Maybe this counts as too much information, but I was sitting in the front row behind Mary Bonato as she was arguing the first case. As you said earlier, I had the good fortune of arguing quite a number of cases at the Supreme Court, at the government, when I was at the Solicitor General's office, and then in private practice. And so I'm used to the pressure that comes with arguing at the Supreme Court, but that day was unlike any other. And as I sat there experiencing the same feeling that you did, a feeling that we were part of history there, there was a moment that I started to feel chest pains. And I thought, oh, this would be a very bad time to have a heart attack. That would not be good. But as I sat there, I knew that it was just the intensity of the pressure that I was feeling. And I had to go through this exercise of saying to myself, there's part of me that just felt that there were so many people, so many hundreds of thousands of couples whose happiness, kind of rested on my shoulders. And then I said to myself, you know what? They're not weighing on me. They're lifting me up. They're all here with me. And I knew that I had some clergy friends who were out on the Supreme Court steps praying for me, and I just had to let them all take that. And I just had to get back to thinking about the business at hand. And eventually that tightness left, and I was able to focus again on what it is that I had to do. But it was a sense that it was a momentous time, and there was much to be won. But it was not a guaranteed thing, and there was a much to be lost too in that moment.
Absolutely, absolutely. And I had the same kind of feeling as you just described on decision day when we came back to the court to hear the court announce its opinion. The second I got in the chair in the courtroom there, from that moment until well after the justices took the bench, I don't think I took a breath. And finally, the court went onto the bench, and the Chief Justice announced that Justice Kennedy would be reading the opinion. And at that moment, I relaxed, exhaled, and finally felt that, things are probably going to be okay.
Well, you exhaled faster than me then, because I knew he was going to write the opinion because he was going to be the swing
Yeah.
justice, right? So one way or another, and I recall that he started, they summarized the opinion from the bench, and he started talking about history. And he said, for millennia, marriage has been defined as an institution between one man and one woman. And that was the same theme he had started oral argument with. He was focused on time and this notion of time, and how marriage had been around as an institution for so long. And I was like, oh, this is not how I want this to start. But then he said, it was only after a sentence or two, he said, but history is our starting place, not our end point. And that's when I was able to breathe. And I it was unlike any other moment I've ever experienced at the Supreme Court, because I just remember hearing the people starting to cry all around us.
Yeah.
And I've said on a number of occasions that besides my own marriage and the birth of our children, there's no other moment in my life that's been more emotional than that one.
Absolutely, absolutely. And I just recall the feeling all throughout Washington that day was just electric. The White House was lit up in pride colors, and there was, practically a little street party there happening in front
Yeah.
of the White House on Pennsylvania Avenue. And it was just a magical time to be in DC, and just felt such relief and such sense of the end of a very long journey, although it wasn't the end. Um, uh, Having gotten to that moment and being able to celebrate that victory with everyone.
Yeah.
Um, so maybe we should turn to kind of since Obergefell now. Um, after the Supreme Court issued its decision, not every state was immediately in a rush to put the freedom to marry into reality. We had a lot of wrangling in our Alabama case, for example, after the decision came down about exactly when it was going to take effect and how it was going to be implemented. And there were proposals to basically change marriage so that same-sex couples would not have the same right to marriage as others. Um, and in other states, there was a resistance to not necessarily allowing couples to get married, but to giving them all the same equal rights and benefits of marriage. And the first place that started to show was in the area of children, raising children. And we, not long after the decision came down, found out about a case in Arkansas where a married couple had a same-sex couple had a child together, and where any opposite sex couple in that situation would just routinely have their names listed on the birth certificate. This couple was denied the right to have both spouses listed on the birth certificate. And we found out about a second couple as well in Arkansas. That case had been brought by an attorney in Arkansas, and we got involved as it went up through the appeals process. And we got, unfortunately, a negative decision from the Arkansas Supreme Court saying that the state did not have to list both spouses on the birth certificate. That seemed to us to be a very clear violation of the principle that was established in the 2015 marriage equality decision. And we knew we needed to take it back to the Supreme Court and make sure that um, the principles established in Obergefell were going to be lived out in reality, and that couples were really going to have all the benefits, all the same rights of married couples. So we turn to you again. and asked the Supreme Court to review that case.
And we were thrilled to have an opportunity to work again, although we had wished maybe we had been defending a favorable decision rather than
Yeah.
having to go up again. But you're right, Chris. It was, there were these shades of the resistance, to Brown v. Board. Obviously, we were fortunate that it didn't have anything near the the violence attendant to that and everything else. But there was no question what the Supreme Court's decision in Obergefell meant, right? It said that these couples were entitled to all of the rights and benefits and privileges of marriage. And here there was a couple, or there were couples in Arkansas that were being denied the right to be listed as co-parents on their child's birth certificate. And the state tried to argue that it was a law about biological relationships, but of course the truth and actual history of how the law was applied belied that, because it was routinely applied in situations where a male spouse could not have had a biological relationship, such as where the male spouse may have been impotent and the child was conceived through artificial insemination. And so the law really was just one of the many, many, many laws on the books that are designed to reinforce the family structure and to ensure that children have the rights to inherit from and have, insurance from and be looked after by their parents, whether they're biologically related or not. And so we took the case to the Supreme Court, making the strong argument that under Arkansas law, this was a privilege of marriage, that the married spouse of the birth mother was entitled to be listed as parent on the birth certificate, and it had nothing to do with biological relationship. And what was rewarding to me in that case was the Supreme Court ruled for us. They didn't even make us go up to argue the case. We won in a summary reversal, and that we won by a vote of 6-3, unlike Obergefell itself, which had been 5-4. By that time, we had picked up the vote of Chief Justice Roberts. He had disagreed with the majority in Obergefell, but by the time the case came back in Pavan, he understood that Arkansas was simply refusing to abide by a Supreme Court order, and he recognized that was wrong. Right? When the Supreme Court has spoken, that's the law of the land. And I was really heartened to see that. And that gave me even more comfort and confidence about the longevity, if you will, of Obergefell.
Yeah, one of my colleagues here at NCLR has characterized the holding of Pavan as, we said what we said. And that was a really important moment, because it was a clear signal to the states that they weren't going to get away with sort of half measures or dragging their feet in complying with Obergefell and implementing full equality for couples. So I guess that takes us to the present. We do hear a lot from folks who are worried about the freedom to marry, who are concerned that the Supreme Court is going to reverse itself and something is going to change. We see resolutions being debated in state legislatures, sort of urging the court to revisit that holding. I think what folks need to know is that the Supreme Court doesn't like to reverse itself very often. It's it's a very slow process if something like that's ever going to happen. And you know, we have seen, and I'm interested in your thoughts on this, we've seen no real sign that anything like a majority of the court is inclined to change anything on the freedom to marry front anytime soon. What are your thoughts about that, Doug?
I agree with you, Chris, and it's not that I'm not worried about it. I understand the counter argument. We saw Roe v. Wade overturned, even though it took 50 years, in a decision that really cast doubt on the logic of a decision like Obergefell, and how the court had assessed the claim of a fundamental right in that case. And so I can understand why some people have concern. In fact, Justice Thomas, in his concurrence in Dobbs, suggested that there were other cases that should be revisited, including Obergefell. But at the same time, you can see in Justice Alito's decision in Dobbs, his making of distinctions about how strong the principle of precedent should be in different circumstances. And he gives as one example where precedent should be most faithfully applied is where people have acted in reliance on a decision in things like making contracts. And of course, marriage is a contract. It's the most important contract of our lives for those of us who enter into it. And those couples build their entire families on the understanding that the law will protect them, right? And so I think even in the Dobbs decision itself, there's the grounds for distinguishing it and coming to a different conclusion with respect to marriage. But I also think that we go back to some of the arguments that we had made that were specific to the recognition issue when we were arguing, for marriage equality. And we made a pitch to some of the more conservative justices that our position was the more faithful to historical precedent, because it had always been the case that once you were married in one jurisdiction, properly, validly under the laws of that jurisdiction, then you were treated as married in every other jurisdiction, even if you could not have married under that jurisdiction's laws when you did. An example of that was if you married at 16 in a state that allowed you to marry at 16, but in another state, the age of consent for marriage was 18. Well, if the 16-year-olds then come back and are married and say then they have a child, they're going to be treated as married even in the state where they could not have married, maybe even they're not 18 yet, right? And that's because it makes no sense. It is internally inconsistent with the notion of marriage that you could be married in some places and not married in other places at the same time. And I remember making the point with respect to Tennessee's purported interests in denying recognition to our plaintiffs' marriages, that they were suggesting that somehow they should forsake their oaths to their actual spouse, act as though they were not married, marry somebody else and have children with that other person. Well, what happens when they move back to New York or they move back to California? Now we have actual plural marriages. We have people who are married more than once. It makes no sense, right? It is inconsistent with the notion of the institution of marriage that you could be both married and unmarried at the same time, depending upon the jurisdiction you're in. Or even think about driving across the country and your marriage goes on and off as you go between state to state, and what rights you have or don't have if you're in a car accident in terms of taking care of your spouse or having insurance cover them depends on, which state you happen to be in when the accident occurred. And so I feel very strongly that if the issue ever came back to the court, it would come back much more like a recognition case, because we have hundreds of thousands, even perhaps millions of couples who are already married. That is the reality of our country at this point. And so, it was significant to me that in the Obergefell decision, although the dissenters all took issue with the majority's analysis with respect to the right to marry, the right to a license, none of them ever addressed the second question of recognition, even though the recognition question in some ways kind of had presupposed a negative answer to the first. And the Chief Justice, I remember, pushing me on that point several times during oral argument. None of them ever addressed recognition. And I think that's because there is no good answer to the arguments that we made. And as I said, I think if it came back, it would look a lot more like that. So I am very optimistic that marriage equality is here to stay. That's not to say that there won't be some scares along the way and some people who agitate, and maybe even some activist legislature, that the state legislature that tries to make things challenging. But I feel very optimistic.
I do too, Doug. The other thing that gives me a lot of optimism and hope here is that we're now living in a world where a country where more than 2/3 of people support the freedom to marry. That figure has been stable for almost a decade. I can't think of any major issue where 2/3 of Americans are on one side. And that's a powerful argument for the case that you made in the court and that we all made to the public over a very long period of time. It's a powerful testament to the courage of the couples who came forward in these cases to talk about their lives and their families and take a risk to protect their families. It's just gives me all the confidence in the world that marriage is here to stay, and that we have really made a lasting change in this country, and that people's lives are going to be richer and fuller in so many ways because of it. So, I just couldn't be happier with this anniversary.
It is a cause for celebration, and I'm sure so many couples who will be celebrating their near 10th anniversary as we celebrate this 10th anniversary of Obergefell. I remember attending quite a number of nuptials shortly after the decision came down. Even in states where it had been lawful before, because couples had decided that they wanted to wait until they knew that their marriage would be valid across the country. So there will be a lot of champagne flutes toasting 10-year anniversaries coming up over the next short period. And I look forward to those marriages celebrating their 20th, 30th, 40th, and 50th.
Absolutely. 100% agreed. Well, thank you so much, Doug, for taking the time, and congratulations to you, and thank you once again for everything that you've done to help us. Take a moment, everyone, this Pride Month to really reflect on what we've accomplished, and to be satisfied with how far we've come.
Thank you, Chris, for your friendship and collaboration. It is such a joy to me to have had some part in this really momentous leap forward.
Great talking to you.
Take care, Chris.